this computer. All right. So, John, good morning. And thank you so much for joining us. We have students who are looking to be effective advocates and learn how to settle cases in a way that advances their clients' interests. And I couldn't think of a better speaker to have to help the class on this journey. So let me introduce you for those who don't know you. So John Lande formally is the Isidore Loeb Professor Emeritus and former director of the LLM and Dispute Resolution program at Missouri School of Law. John Lande is one of the leaders, the innovators in dispute resolution. He has spearheaded the Stone Soup Initiative for the class as part of their curiosity conversations, where they interview colleagues in the field to learn about good advocacy practice. And John is the author of 2 books relevant to our conversation today. The first is Lawyering with Planned Early Negotiation, which was awarded the UL Carey's, the Mangano Dispute Resolution Advancement Award at St. John's Law School. And the second book that has just come out, which is Litigation, Interest, and Risk Assessment. So, so we are happy to have you here today. So let's start with Lawyering with Planned Early Negotiation. What is the important takeaway for our students?
I would say there are 2 important things from that book. Obviously, there are a lot of things. The first is the importance of lawyers developing good relationships with both their clients and their counterpart lawyers. A lot of what goes on in law school makes it seem as if it's trivial or irrelevant or non-problematic to think about the relationship that lawyers have with their clients. When you talk to lawyers about their experiences, those are very challenging, difficult, and it's important to develop good relationships with your clients, and it's tricky. So the book talks about that. The second thing in terms of relationships is it's important to develop good relationships with your counterpart lawyer. In the law school and legal practice world, this is often called opposing counsel, although in fact lawyers who are on opposite side of a case cooperate with each other all the time, and this can make a huge difference in terms of how the case works out. So one takeaway is about developing those relationships. The second is to be aware of 3 different approaches to negotiation. 2 are very commonly taught. One is they use different names for it, sometimes called positional or adversarial negotiation, where parties start off with very extreme positions and they exchange offers and counteroffers to come to some place in the middle. A second approach is what's often called problem solving or interest-based negotiation, and there, in theory, parties identify their interests, try and solve, identify a solution that satisfies both parties' interests by identifying a number of different options. A third approach to negotiation, which is almost never discussed, is what I've called ordinary legal negotiation or norm-based negotiation. And this is actually used a tremendous amount. And this is where there are very relatively clear norms, the facts are fairly clear, and the lawyers or the parties will negotiate in relationship to those norms. They'll look for adjustments to those norms. And so this is commonly used where there's not a lot at stake, where the norms are fairly clear, where the facts are fairly clear. So just to give one example,
Thank you.
If there's child support schedules in divorce cases or parenting cases, and you can come up with a specific amount of child support, and that's the beginning part of the negotiation, and the negotiation takes off from there. So one parent may say, well, maybe it should be a little bit more and provide a rationale for that. The other one might say maybe it should be a little bit less, but they're starting with what the norm is. They're not starting with extreme positions, and they're not identifying what their interests and the options are. So those are the main takeaways from that Lawyering with Planned Early Negotiation book.
Okay, so if which is a lot, and when you were describing it, you talked about lawyers forming a relationship with their client and kind of said, well, that's tricky. Do you want to expand on that, please?
Sure. Well, there are a lot of cognitive biases and social biases that both lawyers and clients bring to a relationship. And the clients often are feeling very anxious and upset and worried, maybe embarrassed that they've done something that they shouldn't have. They're afraid that the lawyers may not respect them, may not take their case. Conversely, lawyers may want to take their case, may want to project confidence. And so there's what we call a conspiracy of optimism, where there's a bias for overconfidence and not being candid in both directions. And so that's one of the tricky parts. Another one has to do with billing arrangements. On the typical hourly billing arrangement, lawyers have an incentive to do more work, and clients often are worried that they're going to do more work than is necessary to rack up the bill. So those are some of the examples of why it's this relationship between lawyers and clients can be very, very tricky.
Yeah, I just to follow up, which how do you feel that racism on the client's part or the lawyer's part might interfere with the relationship?
Well, of course, unfortunately, racial tensions and issues are baked into our society that go back before the founding of our country. And there are implicit biases that we all have. And so it's very, very difficult. And presumably what lawyers and practitioners generally need to do is try to be aware of their own assumptions and biases, and to communicate clearly with clients. I have to say this is not an area that I'm an expert in, but it's clearly an issue that we all need to be aware of and deal with.
All right, thank you. Now, part of when lawyers talk with their clients and they are assessing whether or not it is in the client's interest to go forward with this phantom litigation outcome, right, or to settle, there's usually a lot of bravado and a lot of honest conversation that is missing. And you deal with that in your new book, Litigation, Interest, and Risk Assessment. So when lawyers are, after they have met the client and they're talking about the best strategy for that client, what is a more candid way to conduct a litigation, interest, and risk assessment that the client and the lawyer could live with?
It's, again, a very tricky problem for the reasons I described about the challenges in the relationship between lawyers and clients. And in this book, which I co-authored with two Canadian law professors, Michaela, Keet, and Heavin, we identify three things that lawyers and clients should talk about. One is the expected outcome in court, or if you go to arbitration, in arbitration. This is often called the BATNA in dispute resolution jargon. A second are the tangible costs, which are the legal fees and legal expenses, such as expert costs or costs of depositions. And the third, a very important thing that is often overlooked, are what we call intangible costs, which reflect a lot of interests. Obviously, the parties have an interest in a monetary dispute of getting the most favorable outcome. So the plaintiff wants to receive as large an amount as possible. The defendant generally wants to pay as little as possible. So they have that interest, but they have lots of other interests, such as reducing stress. Litigation is an extremely stressful process for everyone, particularly for the parties. There's delay, there's effect on reputation and relationships, diversion of energy, loss of opportunities. There's a whole laundry list of other interests. And so one of the things that's particularly important that lawyers should be doing with clients is to be doing essentially an inventory, an assessment with the clients of what their interests are. And this book provides a number of appendices with a laundry list of questions to help the clients identify what their interests are related to the litigation.
Okay, so in doing that, so let's get real. All right, this is what we're talking about. And there is a commercial on TV. I don't know if you've seen it. It may be just local, where there are two elderly twin sisters who are talking about this great pit bull lawyer that they have. And as we know all too well, when clients are injured, when they feel a wrong was done, that they want to find a lawyer who is going to fight for them and protect their rights. So that's the desire. At the same time, there's a reality that most cases settle. So how do you suggest that a skilled lawyer who wants to have a good client base have these candid conversations with a client and still is able to retain them? Because in part, this realistic conversation is dispelling a fantasy that wrong people have, right? That they'll go to court, their good lawyer will fight for them, and the judge will agree 100%.
Right. Well, there are a lot of things to do there. And again, the book provides a long laundry list. Some of the most general things would be to start by asking the clients, what's most important to you in this case? And it may be getting the most amount of money, or it may be maintaining a relationship with my sibling. It could be that I need to get this over soon because this would take over my life. So asking the clients what's important to them, why they haven't settled already, because most disputes, people never go to lawyers at all, let alone go to court. So the fact that they haven't reached an agreement means that there's some problem or barrier. So there's a series of questions like that. A lot of times in terms of getting the best outcome in court, one of the things that's really important for the parties to know and for your law students to know is that first, most cases actually do settle. And so although the parties have these fantasies based on TV and movies about these great court victories and these wonderful dramatic trials, that happens in a very small percentage of the case. In federal courts, it's typically 1% to 2% of the cases. In state courts, maybe somewhat more, 5 or 10% would be a lot. So in most cases, there's not going to be a trial, let alone these appellate cases that students read all the time in law school. So part of it is that they need to understand that they're going to be, and that the clients and your law students need to understand that most cases are going to settle, they're not going to go to trial. Of those cases that go to trial, there's research, several studies have found very similar results, that in at least one of the parties gets a result worse than the other side's last offer. So for example, if you're my client and we get an offer, you're a plaintiff, and we get an offer from the defendant for $100,000, and then we go to trial and you get an award of $50,000, this is a bad result for you. You would have been much better off to accept the $100,000 offer, not to mention saving the time and money and stress of continuing the litigation and going to trial. So part of what's important for the clients to understand is that it's very difficult to make accurate predictions about what would happen in court, and that most cases that do go to trial, one side or the other makes a mistake. So what I would suggest, and what we talk about in the book, is asking the client, well, do you want me to be honest with you, or do you want me to lie? Do you want me to give you some fantasy about how we're going to go to court and necessarily win, or do you want me to give you a realistic assessment about what the strengths and weaknesses of the case are, what the risks are, what the possibilities are? if you ask people in that way, most clients are probably going to say, yeah, tell me the truth, don't lie to me. But it's a tricky thing to do because of the tricky relationship between lawyers and clients.
Yeah, yeah. So, but it sounds like what you're suggesting is if you are transparent and authentic with the client and ask them if they're ready for you, if they want you to be truthful, that's something that they are going to opt for more often than not, hopefully.
Many of them will.
Yeah.
It helps if you start first by asking them about their interests. What's most important to them? Tell me about the facts of the situation. One of the things that some lawyers don't do very well is that they focus only on the legally relevant facts. And of course, the clients don't necessarily know what's legally relevant or not. They're going to tell you what's important to them. So my advice to your students when they're out in practice is to pay attention to what the clients are saying, whether it's legally relevant or not, and not turn off your mind and say, oh, that's not relevant to what would happen if we went to court. If they're telling you about it, it's relevant. So pay attention. And if the client understands that you care about them, you want to understand their perspective, you want to help them achieve their goals, which may or may not be winning in court, then they are likely to be more trusting of you and have that good conversation about what the likely outcome of litigation would be.
Okay, good, good. So part of what you're saying is even though law school spends all this time helping students think like a lawyer, you're saying to have a very good discussion with clients that you have to, in part, park your legal mind on the side and have a human conversation and hear about the human concerns of your client before you start dealing with the legal issues.
Yeah, and so basically you need to do both to be considering what the legal issues would be. Certainly you're going to want to be thinking about what the potential outcome in court would be, because that's going to be obviously relevant in litigation in terms of how you would pursue the case. It will be relevant in terms of your negotiation strategy. So you're going to need to know all of those things. And you also need to have a good relationship with your client and have them feel that you care about them and that you're really doing your best to help them achieve their goals.
Good, thank you. So one last question. So if some clients come in and they already have a signed contract where they're obligated to arbitrate their cases, does that mean that the lawyer needs to just work with the client to prepare for arbitration? Or do you suggest that the lawyer should engage with the client and have and discuss and assess whether or not there are other interests and they could work with the client in another way other than in arbitration?
Well, a couple of things. One is that, just like in litigation, most cases where there's a demand for arbitration because of a contract or even an agreement to arbitrate, only a fraction of those go to an arbitration hearing. Most of them get resolved short of that. So you're going to want to have a conversation with the clients, very much like what I described about litigation, and the same structure would apply, just making adjustments to reflect the differences with arbitration. So, for example, in arbitration, often, it varies a lot depending on the context, but often there isn't as much opportunity for discovery. Well, that has a couple of implications. One is you're going to have less tangible costs because of that, but you're also going to have maybe less confidence because you don't know the facts as well. You don't have as much evidence as you would if you were in litigation. And so that will affect your risk assessment. And one of the things that makes a huge difference to clients is their risk tolerance. A lot of clients, a lot of parties are very risk averse. They're afraid of losing. And so if in arbitration, if you know less about the case, you may have less confidence that you're going to win, and therefore you may be more likely to settle or to settle on less favorable terms because you're less willing to take a risk. Another difference is that there's less published authority in arbitration. In some contexts, there's virtually none. And so whereas you, again, in litigation may have more confidence that you'll have a sense of what the outcome might be in court, you probably have less so in arbitration. This is something that our friend and colleague Jill Gross has written about, negotiation in the murky shadow of arbitration. A wonderful article about that. And then another factor is that in arbitration, the parties pay arbitrators' fees, which can be substantial and typically much more than if you go to litigation. So you make these adjustments. Again, it's a case-by-case analysis. The same three elements apply: what the likely outcome would be if it's adjudicated, what the tangible costs would be, and what the intangible costs and interest would be.
Okay, thank you so much. A lot to think about. Before we end, let's have the human conversation. So the way we're encouraging our students to do. So fortunately, John and I have a long history. And one of the special endearing parts that I want to share with all of you, because I guess it's similar to what you were saying about develop relationships with all your colleagues. So when we would be at conferences, all dispute resolution conferences all over the country, John would be the person that would memorialize these great times by taking pictures of everybody who would be at the conference. And he would make sure everybody would be smiling. Would you share with the students the magic that made sure everybody would smile?
I'm going to tell you about it. I'm not going to demonstrate it. But I would shake my hips, which while I was taking the picture, and this infallibly produced gales of laughter. People have never seen anything so absurd as me shaking my hips. And so it would produce these smiles, which then produced very good photos. So I have not only taken and shared these photos, but I have posted albums of these photos on the Indisputably blog. If you search for photo album, you'll see one blog post that has a collection of all of these photos that go back actually to before 2000. I've been around for a while. I'm an old guy. In addition to the photos that you're talking about at conferences, what you may not know is I have a photo of every class I have ever taught. And so I would use the same technique for my classes, and I have photos of them. And I'm very proud that one of my former students is a disciple, Sukhsimran Singh, who is at Pepperdine, and he tells me he uses the same technique.
Something to consider. John, thank you so much for your graciousness and your wisdom. And you gave our students a lot to think about. Thank you.
I hope so, and appreciate the opportunity. One last plug about, again, the Indisputably blog. If students are really interested in dispute resolution, I would encourage them to subscribe, and there are a number of colleagues and friends who post things of interest, and so they might want to check that out.
Yes, thank you.
Thank you.
Stay healthy and stay safe.
You too.
All right, thank you.